Ms. Lynch, thank you for your endurance in what has been a long, extended hearing. I would ask in this round of questions if you could try to keep your answers brief, because we've got to return to votes on the floor. In the prior round, you and I had a conversation about the OLC opinion and the President's executive amnesty, and you stated your agreement with the legal reasoning in that OLC opinion. And I would like to explore the limits of that reasoning. As you know, any legal theory that is being put forth to justify government power naturally raises the question, what are the limits of that power? And one of my greatest concerns about the Holder Justice Department is at every turn, when asked what are the limits on government power, the answer has been there are none, there are none, there are none. So let's talk about the limits of the prosecutorial discretion power. The OLC memorandum justifies executive amnesty in part based on prosecutorial discretion, and initially that was limited to some 800,000 people in the original DACA. Then in the subsequent executive amnesty, that expanded to 4 or 5 million people. My first question to you is in your understanding of prosecutorial discretion, is there anything to prevent that from being expanded from 4 or 5 million people to all 11 or 12 million people who are currently here illegally?
Well, Senator, as I read the legal opinion, it was focusing on how the Department of Homeland Security could best execute its executive discretion in prioritizing removals of the most dangerous of the undocumented immigrants among us. Then with respect to those who would be a low priority, it focused on the legal framework for setting up a deferral program. And as I also read the opinion, it went through a legal analysis that indicated that part of the request did not have the requisite legal framework and should not be implemented. And my understanding is that that particular part of the request was not implemented. So I think that with respect to any action, certainly should I become confirmed as Attorney General, I would undertake a very careful legal analysis based on all of the facts presented to me by whether the White House or whatever agency raises the issue. We would look at all of the precedent, congressional action, the relevant statutes, and carefully explore whether or not the requested action did have a legal framework. If there was, in fact, a reasonable basis for it, as was outlined in the opinion that I read, that information would be provided. But, as also was outlined in the opinion that I read, where the legal framework did not exist to support the request or the proposed action, that would have to be told to the requesting department.
Ms. Lynch, let me try again, because you described the memorandum, but I asked a pretty straightforward question. Would prosecutorial discretion allow the President to decline to enforce immigration laws against all 11 to 12 million people here illegally?
Senator, prosecutorial discretion as a tool, certainly as I have used it as a career prosecutor and U.S. attorney, would focus on which cases to prosecute and which types of charges to bring. It would not apply to the situation that you have outlined, so I'm sorry if I'm not able to answer your hypothetical in the way in which you are requesting. As I have utilized prosecutorial discretion throughout my career, it has been with the presentation of cases before me and determining the best way to focus limited resources.
Well, and of course, this is not simply prosecutorial discretion, because in addition to stating that federal immigration law would not be enforced with respect to somewhere between 4 and 5 million people, the President also announced that the administration would be printing work authorizations in direct contravention of federal law. Now, are you familiar in your practice as U.S. Attorney, when you have declined, when you've used prosecutorial discretion to prioritize prosecuting one crime versus another, have you ever engaged in printing up authorizations for one set of individuals to violate the law, to affirmatively violate the law, which is what these work authorizations consist of?
Senator, in my practice as a career prosecutor and U.S. attorney, I have focused on bringing the strongest, most effective cases based on the facts and the law that have been presented to me. Also, in referring those cases to other law enforcement agencies, should my venue not be the most appropriate one there?
Ms. Lynch,
With respect to-
sorry to interrupt, but we're on limited time, and what I asked is if in your practice you ever issued authorizations to violate the law, and that, I'm certain the answer is no, but am I correct in that?
Certainly, Senator, in my practice, I focus on building the most strongest, most effective cases against the perpetrators who come before me, and referring them to other jurisdictions if I'm not the appropriate venue.
Ms.
Would not
Lynch,
be part of my responsibility to
Ms.
make a
Lynch-
determination
Ms. Lynch,
in the
you
matter
are-
you're referring to.
You are a very experienced prosecutor. You have asked questions and had witnesses decline to answer. This is a simple question. Has your office issued authorizations for individuals to violate federal law?
Senator, as the U.S. Attorney, our office is not involved in issuing authorizations for anyone to work or not work or to engage in various activities. We're not a licensing authority. So I'm just not able, unfortunately, to answer the question as put to me.
So your office has not. Are you aware of a precedent for the federal government doing what the administration is doing right now, which has hired over 1,000 people? It is printing millions of authorizations for individuals to violate federal law. That is a remarkable step, and it is a step that goes much further than simply prosecutorial discretion. Are you aware of any precedent for hiring over 1,000 people to issue authorizations for individuals to violate federal law?
Senator, I'm not aware of the practices that you are referring to now, nor am I aware of how the particular remaining portions of the executive action are being implemented, so I'm simply not able to comment on the hypothetical as presented to me or the particulars that you've given to me. So I'm sorry I don't have the information to answer your question.
Well, then let me understand the limits of the legal theory you're putting forth, because you, in prior questioning, embraced the prosecutorial discretion argument. And so Senator Lee asked you a minute ago, let's take the hypothetical Senator Lee asked you about. If a subsequent president, let's say President Cornyn is sworn in January of 2017, and if President Cornyn decided that he was going to instruct the Secretary of Treasury not to collect any taxes in excess of 25%, to exercise prosecutorial discretion and not collect the taxes, in your legal opinion, would that be consistent with the Constitution?
Senator, before I could render a legal opinion on the hypothetical as presented to me, I would want to know the entire scope of the action, but also have the time to gather all of the legal precedent, the cases, congressional actions, any other similar or dissimilar actions where that particular type of action might have been considered. So I would certainly want to have all of that before I provided a legal opinion in terms of the hypothetical that you've presented to me.
So you're unable to give any legal judgment to this committee today on whether a subsequent president could decline to enforce the tax laws as they're written?
I think with respect to current or subsequent presidential action, there would have to be, as in every case, a thorough review of the relevant law, the precedent, congressional precedent, the statutes in issue, in conjunction with whatever action was being proposed to see if there was, in fact, a legal basis or whether there was not a legal basis for the action being proposed.
Well, and let me ask, and this will be my final question, your understanding of prosecutorial discretion. Would it allow a subsequent president, President Cornyn, to state that there are other laws that the administration will not enforce, labor laws, environmental laws? Would it allow a President Cornyn to say, every existing federal labor law shall heretofore not apply to the state of Texas because I am using my prosecutorial discretion to refuse to enforce those laws? And in your judgment, would that be constitutional?
Well, I certainly can't imagine President Cornyn taking that step. But with respect to the hypothetical that you present, again, Senator, I would have to know what legal basis was being proposed for that, and certainly I would review that law, and if I were the person providing advice to future President Cornyn, advise him as to whether or not there was a legal framework for it or whether there was not a legal framework for it. If there was not, that would be the advice that I would provide to him.
I must say I find it remarkable that you're unable to answer that question. I can answer it straightforward. It would be patently unconstitutional for any subsequent president to refuse to enforce the tax laws or the labor laws or the immigration laws for the very same reason that President Obama's actions refusing to force immigration laws are unconstitutional. And it is discouraging that a nominee who hopes to serve as Attorney General either will not give a straightforward answer to that question. My time at this point has expired, so I recognize Senator Franken.